So smart. I'm an enrolled agent trying to keep you updated on the latest on the employee retention tax credit. Please like and subscribe so other people who are looking for this content can find my channel. So as you know, April 15th has passed, and that was the final deadline for applying for the employee retention tax credit. So it's no longer available for you to apply for it. So what we're mostly looking for is, are these things being processed, and when am I going to get my refund? So here we're showing the processing by week as to how many claims have been processed. See along the bottom here, less than 1,000 per week. Slowly but surely, I'm hearing of my clients getting checks. You've gotten yours. If you wouldn't mind putting a comment below when you applied. I do have people outstanding who applied in 2022 who have not received a check, and some from 2021. So what is the good news is they are increasing a little bit in the amounts. So some of the people higher amount brackets are getting checks. I have some clients getting them in the 300,000 range. So that is good news. There's also less denials that are coming in. That has decreased. So we are hoping for these things to pick up. I still don't see a big pickup. What I have also found is for the companies who the IRS has made errors on, and there are quite a few, the IRS is very slow to respond. Some of these people, I've corrected the errors with the IRS in 2021 and 2022. The ball is in their court. I've had the ERC, the 941X form applied to the wrong year, the wrong quarter, all kinds of things that had. They're still waiting for the IRS to straighten that out. They're sending threatening letters that the client owes the money when they don't. It's the IRS mistakes that have been made, and they're just slow. And I'm hearing this across the board. They are trying to get rid of some more of the employees of the IRS. And as it is, it's very hard to get anything done. I think they're just overwhelmed. They need more help to be able to process these. They need more direction. And it's very difficult if you are one of the people who has a problem with your ERC claim. You're waiting for a response. You'll just keep getting these letters. We need another 60 days. We need another 60 days. And just slow. You're not alone. That's just what's happening. Now, in other news, PEOs, some of these larger PEOs companies, and you'll know if you're a PEO because the 941s are not filed under your EIN. It's filed under the PEO. That's Professional Employee Organization, and they co-employ your employees for you. So they have to file for the ERC, and that would be ADP, Total Source. It's the PEO. ADP also has regular, so that are not PEOs. So TriNet, some of these larger PEOs, I know they submitted very late, but they are huge claims, and they just have not received them yet. I talked to both TriNet and ADP this week, and they have not gotten the IRS for their PEO clients. Here is another lawsuit where somebody had to file to get their ERC refund. It's just utterly ridiculous. This was a claim, 3 wise men. They had a reduction in gross receipts, which is pretty straightforward. You can't really deny that. It's a straightforward claim. They had to file a lawsuit in order to get their refund, and obviously it's been dismissed now. They've gotten paid. So the original instruction was that if you got your ERC based on wages paid in 2020, that you need to go back and amend that tax return and reduce your wage expense by the amount of the ERC refund. And then if you had wages in 2021 for which you got ERC, you need to also amend that return. Well, lo and behold, the IRS took so long that the statute of limitations expired. The statute of limitations for amending your tax return is 3 years. So now it's too late to amend 2020 and too late to amend 2021. We've been thinking that was just, we were thinking that could happen, and the IRS kind of shot themselves in the foot, because now if people got paid for 2020, they are disallowed from going back and amending that tax return and basically claiming additional income and paying more taxes. So here is the new frequently asked questions. I talked about this on another video. I should have reduced my wage expense on my income tax return when I filed for the employee retention credit. What can I do if I didn't do it and now it's too late? Now, I've told you on some other videos, I'll repeat this, that some people went back and amended their year 2020, but it was past that statute of limitation. The IRS returned it to them saying it's past the statute. We cannot accept any amended returns. That's just standard law. So now what? Did we just don't have to claim the additional income? So now with the IRS, it said you should have done that, but now we have a new direction. That new direction is you can now amend your tax return and claim the additional income in the year you got the refund. So in other words, if you got your refund in the year 2024 and it was for wages paid in 2020, the same instruction would apply, which is you would amend, or I suppose you haven't filed 2024 yet, but you would reduce your wages in the current year, in the year you received your refund, by the amount of the refund. So now they're giving this new instruction, and they're also telling us the same thing. They're also telling us, what if I was expecting on getting the refund, the ERC refund, and so I didn't end up getting it. It was disallowed, but I already amended my tax return and reduced my wage expense by the amount I was expecting to get for the ERC. And again, they have said you can take this into the current year. If you're appealing the decision of the disallowance, don't go ahead and adjust yet. Wait till it's basically become final. If you're appealing it, just wait. But then you can now claim you can now add the additional wages that you reduced your amended return by. You can add those back in the year when it becomes final that you are not going to get the ERC. Now, I just want to point out that we're looking at these frequently asked questions, and we're following these rules, but frequently asked questions on the IRS website do not have the weight of the law. So what they've done now is they've reinterpreted previous law. So the previous interpretation was to go back and amend, and now they're saying, oh, you can take it in the current year. So it's a reinterpretation. Isn't that fine and dandy? Because they were going to miss out on getting additional taxes paid to them, because once you got the ERC, you have to reduce your wage expense, thereby increasing your net income. Now, they refer to certain sections in the law in these frequently asked questions from where they decided to reinterpret the law. They're now saying it's okay to reduce your wage expense in the year you got the ERC, which I wish they would have done originally and save us all this trouble. Or if you had a disallowance, you can claim back those wages that you deducted on your amended tax return. So now there are a number of us as tax professionals have said, yeah, but it's not a law. Now you've reinterpreted a law. I'm a little iffy on this. So I don't really want to tell people you have to do it this way or you have to do it that way. I'm kind of in this waiting mode because this could be challenged. And it's a reinterpretation of the same law that they used for making the original instructions. So I'm sharing with you, this is Ashley Hall. She's a tax attorney, and she goes into, describing this, which all of the tax professionals have been saying. Frequently asked questions does not hold the weight of the law. It's a great solution, kind of late, but it could be challenged. So the application of the rule corrects the taxpayer's wages in the current year, and they justify their position by a reinterpretation of the same law. So it's a little bit, in my opinion, I think I would wait and see, because as I've said before, on some of these lawsuits, the Stinson-Temidin lawsuit, which basically invalidated how the IRS described how you qualify for partial suspension. And that is based on the IRS making interpretations of the law that could have been an APA violation. And since the IRS did not post and take comments on these interpretations of the law, then it would be an APA violation if this interpretation of a partial suspension was held as a hard and fast rule. So we've already been through this, and I've encouraged people to stay in the game, even if you get a disallowance. If you're kind of in a gray area, I'm not saying lie to the IRS. I'm just saying there's some hope that these laws are not hard and fast laws. So this is the same case here. You can talk to your tax professional and decide how you want to handle it. If you want to go ahead and claim it in the year you got it, or if you want to wait and then maybe have some more interest that you have to pay on late taxes if you do in fact file it. I'm not giving you tax advice. I'm just saying this is a bit of a gray area. It's a reinterpretation of an old law. And I don't know if it'll hold or it won't hold up, but I will say you cannot use frequently asked questions in tax court. Now, you could maybe say, I follow this guidance, but it's not really going to help you in terms of an outcome in a law case, because it is not considered to be law. Now we can wait and see, will the IRS go through the steps it needs to go through to make this a law? Well, let's see. So this is Michelle Smart. I'm an enrolled agent, trying to keep you updated on the ERC. Please like and subscribe so other people can find this content. Thanks again for watching.